Next case on the docket is Whiting versus Whiting. Okay, whenever you're ready, sir.
Good morning, Your Honors. May it please the Court. My name is Shane Bowdy, and I represent the appellate Jeff Whiting in this case. Also at the table is co-counsel Clayton Simmons. I would ask that the Court allow me to reserve 5 minutes of my time for rebuttal.
Okay.
Thank you. The appellee filed this action to set aside the Second Amendment to the first restatement of the Lorraine Y. Whiting Trust, and Ms. Whiting is the party's mother. They are brothers, and this particular action was granted by the lower court in an order summary judgment, which is on appeal here today. The appellant has raised several issues. The first is that the trial court erred in not applying Florida Statute 744.3446, part of the guardianship law, as a plain reading of that statute actually allowed Ms. Whiting to retain all the legal rights not granted to the guardian in a limited guardianship, including the right to change her testamentary plan, the right to change her will, and the right to change her trust.
Mr. Bowdy, if you go straight to the order appointing guardian that was signed by the trial court in February of 2010, which, as I understand it, was the basis upon which the trial court granted summary judgment. First of all, paragraph number 1 is entitled Management of a Business. What business was Ms. Whiting engaged in?
There was really no business. The family owned a limited partnership, which I believe is really subparagraph 2 there. There was not any business sense. The partnership did have some cows on the property. There were some leases. Basically, the partnership owned 1,500 acres in Volusia County.
So why was it referred to as a management of a business if there was no business? Because it would seem to me that the balance of that paragraph that talks about limitations on her check writing ability to incur debt on credit cards and transfer any real property has nothing to do with any business.
Unfortunately, I was not counsel in that case, and it was done quite a while ago. However, to my understanding, there was no business. Again, the limited partnership and the trust itself were the only things other than her personal account that I'm aware of that she had. So there was no separate business account.
And where is it in this order or in the stipulation that was essentially ratified by this order, a limitation on her ability to change her estate plan?
It's not, and that's our argument, that the trial court basically went beyond what this document states in ruling as a matter of law that the document itself precluded or barred Ms. Whiting from changing her testamentary plan, her trust, and her will, when in fact what occurred was after Ms. Whiting's passing, this action was brought by the appellee to set aside what she had done based on this document. And the appellee brought forth the terms gift and reduction of debt, the limitations that are in here in paragraphs 5 and throughout, as saying that that language somehow was a limitation on her testamentary devise, when in fact that's what really kind of created the ambiguity that the appellant's counsel argued at the trial court level.
So under paragraph 5, could Ms. Whiting give a gift of $5,000 to her church?
According to this, yes, because this limitation was only based on persons related to Ms. Whiting by blood only.
Okay, well, how would that square then with the language in paragraph number 1 that imposed a $1,500 limit on writing a check if she wanted to give $5,000 to her church?
I can't square that at all. And that's really an inconsistency with this particular stipulation and order, which again brings out more ambiguity. All of these things, again, were brought before the trial court, and in fact, at the summary judgment hearing, there was an argument that's in the transcript between actually myself and the judge regarding these limitations and whether or not, what does the word gift mean? And her statement at the time, the trial court statement, was that a gift is the ultimate, that testamentary devise is the ultimate gift, and therefore, somehow the word gift, when you read this whole document, it really is pretty understandable and clear that they were attempting to limit what she was doing right there in the moment, writing checks, not being able to write all of her money out of her account to some salesperson that came and knocked on the door, those type of things. And that's pretty clear in here. But the limit on her testamentary devise and her changing her will and or her trust is not at all enumerated in this document.
And the underlying trust was a revocable trust, meaning she could have it, have certain provisions on Monday and on Friday. She could change those provisions if she wanted to.
Absolutely. She always maintained that right to change that. It was a revocable trust that was actually enacted back in 1993. So she had that trust and maintained that trust for quite a long time before this particular occurrence ever happened.
And your position was it was a voluntary guardianship?
No, actually, the trial court made that mistake as well, which is highlighted in the appellant's brief. We never made...
Well, wasn't the back and forth between the trial court and the parties was the parties agreed that it was a limited voluntary guardianship, correct?
Well, they argue, the appellee argued that it was a stipulated limited guardianship, and therefore, I guess the rules of the guardianship statute 744 did not apply.
Nobody objected to that, right?
No, absolutely, it was objected to. That the rule, in fact, we brought up that
In the hearing?
Yes, in the hearing, that the guardianship statute 744, specifically section .344 subsection 6, did apply, and that was the only law that should apply, because when the guardianship...
I didn't see, though, an objection when the trial court, in the back and forth with counsel for Ms. Whiting, the trial court, and I think it was the testimony of Ms. Barton, there was ultimately the court said basically we're looking at a limited voluntary guardianship. At that point, there was no objection, correct?
Now, are we talking in the summary judgment hearing? Are we talking the back when...
I believe so, yes.
The parties were entering into the guardianship, because...
Entering into the guardianship that
Okay.
Ms. Barton was providing her testimony.
Yeah, I believe that is. And in my reading of that, you're right. At that time, all the counsel that was there did say, and in that transcript they do attest to the fact that, yes, this is a voluntary limited guardianship. And that is what they attested to. And I guess that was in open court, and then they reduced that to here.
Here's what the transcript says. Ms. Barton, yes, I met with Ms. Whiting and her family last week and reviewed it. A little unusual. It's a limited guardianship of the property, and it's the court's expectation that this is a voluntary guardianship, question mark. It's a little unclear to me. The court, well, the stipulation seems to appear to me that it is what you contemplated. Ms. Whiting's attorney, yes. Appellant's attorney, yes. So, I mean, it seems to me like what they were stipulating to is that it was a voluntary guardianship.
Correct, and I believe that was the premise at that time. However...
That was the agreement, wasn't it?
Correct. Again, although it says limited, and there's nothing in here that says voluntary guardianship. So The document, unfortunately, is very confusing.
What kind of guardianship is it then?
Well, that's one reason why the professional guardian, Teresa Barton, at that time refused to serve, because when she read this order, and when she read the proposed order, or the proposed
What kind
letters,
of guardianship do you say it is?
I say it's ineffective as a guardianship.
It's what?
Ineffective as a guardianship.
It's not a guardianship at all?
I don't believe so. I think that under 744, the rules that are there that set out what is required to enact a guardianship were never complied with. As a limited guardianship, there needed to be an order statutorily that required the court to find an incapacity. There was no order of incapacity ever in the guardianship case, which is required under the statute.
And wasn't there later on, when there was a second stipulation and order signed, attached to that was the report, I believe, from Dr. Danziger, that Ms. Whiting was competent to agree to the voluntary guardianship. And so ultimately what happened was there was a voluntary guardianship imposed in this case.
Yes, a year and a half after this particular order, and unfortunately only about 5 days before her death, they did enter into finally a voluntary guardianship. So the capacity and the order and the requirements of that voluntary guardianship under the statute were all met.
And there has never been any finding, at least, and if it's in the record, maybe I missed it, but there's never been any finding by a court that found her to lack capacity.
Correct. There was no finding, and actually in the trial court's order summary judgment, she notes that there was no finding of incapacity ever for Ms. Whiting. Unfortunately, that guardianship case is just a mess of pleadings, and where I believe in the record that was sent to the court, we gave the court what was necessary as far as this case. That particular case went on for almost 3 years. And while there were certain examining committees, in fact, 2 different examining committee timings of three different examining committee members, there never was the proper, again, statutory requirements followed in the timing of a hearing after those committees to attest to her capacity or lack thereof. And yes, there was conflicting evidence, and they never did the proper requirements to either find her incapacitated or otherwise. So none of that was actually a part of that guardianship hearing. A few other issues that were raised by the appellant is that the trial court erred where there were genuine issues of material fact that were argued before the court, and where the appellant had brought forth 6 different affidavits. The attorney, Jim Barks, who actually drafted the changes to Ms. Whiting's trust and her will, including the Second Amendment that was attempted, that the appellee has attempted to have set aside, all of those in support of the appellant's position. Also, the trial court erred in not allowing the affidavit of Ms. Whiting's then attorney, William Whelan, in, and the argument there was that it violated the parole evidence rule as well as the Florida Rules of Evidence Code. And although the trial court actually used part of that particular affidavit of Mr. Whelan in her order, she makes a finding of fact in, I believe it's paragraph 11. The trial court makes a finding of fact here talking about the negotiations required to retain the power was to require the approval of the beneficiaries. All of that comes directly from Mr. Whelan's affidavit, and then yet the next line says, nonetheless, the entire affidavit is of no merit. So she makes a finding of fact and then says that the affidavit isn't valid, and then goes on to say that the parole evidence rule bars that particular affidavit, when in fact it wasn't just under parole evidence, but obviously because of the ambiguity, but it was also brought forth to attest to Ms. Whiting's state of mind at the time the stipulation was signed by her attorneys. Again, I think that's an issue to note, that the stipulation was never agreed to by Ms. Whiting, it was never signed by her. The only signatories to that stipulation, which this order in 2010 is based on, was the attorneys themselves.
Did Ms. Whiting sign the later stipulation?
She did. She did. Later, she signed the later stipulation, and then, of course, the voluntary guardianship. So, again, let me, and I know we kind of skipped around a little bit here. In the court's denial of Mr. Whelan's affidavit, Attorney Whelan's affidavit, as far as the parole evidence rule, Mr. Whelan's affidavit did not contradict the written terms of the stipulation. It merely explained, again, the parties' understanding and intent. And the rule under the evidence code would allow that under Rule 90.803, subsection 3, as far as Ms. Whiting's intent and as to what her understanding of the document was, as well as her state of mind.
What is the remedy that you're seeking?
Well, we're seeking actually one of two things. First of all, that this court rule as a matter of law that based on the application of the plain language of Florida Statute 744.344, that Lorraine Whiting was not barred by the 2010 stipulation and order from making changes to her testamentary documents, her will, and her trust. In the alternative, reverse and remand for trial based on all of the conflicting evidence here and the genuine issues of material fact that were brought forth. Also, the court's abuse of discretion in not allowing the affidavit of Attorney Bill Whelan.
You got about 5 minutes left if you want to reserve the time.
I'll reserve the rest of my time, Your Honor. Thank you.
Please court, my name is Frank Pierce. I represent Anthony Whiting, the appellee in this case. From the questions of the court, let me see if I can give you a little bit of the timing here on the guardianship orders. There are actually two guardianship orders. One is a stipulated limited guardianship. And how that arose, I was counsel during that guardianship. How that arose was we were in the midst of a trial to determine Mrs. Whiting's competency when Mr. Whelan approached, wanted to see if a resolution could be resolved. We then entered into this stipulated limited guardianship. And this is not a voluntary limited guardianship because Mrs. Whiting did not retain the power to avoid the guardianship. Under a limited guardianship, a voluntary guardianship, the ward can always simply file a document that terminates the guardianship, and that was not what occurred here. Mrs. Whiting did not have that power under the stipulated limited guardianship. Then we go forward in time to the time when Mrs. Whiting executes the Second Amendment to the first restatement of the trust. That followed the entry of the order on the stipulated limited guardianship, but predated the second order of guardianship, which was a voluntary guardianship.
Mr. Pierce, where does the, in looking at the first set of documents, because that's what the trial court relied upon in granting summary judgment to your client.
Correct.
Where in the first set of documents, either in the stipulation or the order appointing guardian upon a stipulated limited guardianship, does it explicitly say that Ms. Whiting no longer had the power to change her estate plan?
There is no specific language that says she does or doesn't have the power to change her estate plan. What it does say, under paragraph 5, is that all gifts by Lorraine Whiting will be limited to a maximum of $1,500 per person in any form. And it's the in any form language, whether it is inter vivos or whether it is testamentary, that creates the limitation for any gifts which would include cash goods, services, tuition, scholarship, loan repayments, advances, debt reduction or elimination, or to persons related by Ms. Whiting, to Ms. Whiting by blood only per calendar year. Now, that's exactly what the change to the trust did. Mrs. Whiting's original plan in her trust, the 2003 trust, the first restatement, recognizes that Jeff Whiting got $153,000 in essence advance. In order to true up to the two other brothers, Mrs. Whiting in her first restatement indicated that Anthony Whiting and his brother, then deceased at this time, Nicholas Whiting, were to get $153,000 as first payment plus 6% interest per annum. The Second Amendment to the first restatement, which is at issue here, eliminates that completely. That is a dead elimination. There is no question, and the court found that there is no genuine issue of material fact. And in fact, in the appellant's answer to the complaint, they admit that. They admit that in their answer, that this was a debt elimination and debt reduction. There was also a gift of the trust property. The trust owned 3 pieces of real estate: Mrs. Whiting's home, her homestead, a contiguous adjacent parcel, and a parcel across the street. The prior first restatement of the trust was to divide that among the 3 children equally. The Second Amendment, which is the subject matter of this claim, eliminates Anthony Whiting, the appellee, and eliminates his deceased brother, Anthony Whiting, as a personal representative of his estate, from that. So there was clearly a gift of real estate plus a transfer in interest in real estate, and that is the equitable interest in that real estate.
So under paragraph 5, then, Ms. Whiting could change her estate plan to completely disinherit all of her children and leave the bulk of her money in the estate to some charity. Because isn't paragraph 5 limited to persons related to her by blood only?
That is what is stated, Your Honor.
So if, in fact, she had changed her estate plan or her trust and said, I'm not making any provisions now for my children, and I'm going to leave it all to my favorite charity, then there would be nothing for your client to complain about.
Correct.
Because under this document, she would have the power to make that change, correct?
Yes, she could.
Okay, and that does not conflict with paragraph 1?
No, it doesn't, because paragraph 1 involves her personal financial affairs as well. What the purpose of this process was to do was to try to take care of Ms. Whiting. And it's both in a financial and a non-financial way, and that is, Ms. Whiting, I think, at the time of this was in her 90s, maybe 91, 92, at the time of this event, and she needed to have peace. This was designed not only to protect her financially, but to bring peace.
But wouldn't you agree, looking at the record in total, that there was 3 years of no peace when both Anthony Whiting and Jeffrey Whiting were challenging one another and their mother in these guardianship proceedings? These were extended proceedings, correct? So arguably, there would be no peace to Ms. Whiting until that final set of documents were signed shortly before she passed.
Not really, Your Honor. The intention of the parties versus what actually occurred, nobody has the gift of clairvoyance to see what's going to occur once the stipulation's put into place. My client wanted to spare his mother the ignominious ruling that she was not competent. There were numerous findings by the healthcare reviewing committee that said that she was not competent. We were on that track in a trial to have that determination made when Ms. Whiting's counsel, Mr. Wheeland, approached and said, can't we resolve this short of that? And so in an effort to try to bring that peace, to protect Mrs. Whiting, to stop the outflow of cash, the stipulated limited guardianship was entered into and confirmed by Judge Galuzzo in his order. And that order went forward. Ms. Whiting changed lawyers. She had a court-appointed lawyer, then Mr. Wheeland, then Mr. Green. Why she made these elections and changes, my client doesn't know. He was not consulted on any of those.
Why was there a provision in the original order and the stipulation limiting her acting as a member of a partnership?
Because she was the general partner of a family limited partnership. That limited partnership had been in existence since the 90s. The subject matter of that limited partnership is 1,200 acres of land here in Volusia County that fronts on Maytown Road on one side and fronts on the St. Johns River on the other side. When the emergency temporary guardianship was instituted, she became statutorily dissociated as the general partner of the limited partnership.
Your client took over control of that property.
My client was the successor general partner under the limited partnership document. Yes, Your Honor.
And so, and if I understood the record, there's currently litigation between your client and Jeffrey over that parcel of property in Volusia County.
That has just been, the appeal on that was just dismissed in this court last week, and that action, which was filed in Volusia County, it now goes back for cleaning up and closing up. So that litigation's been terminated.
Okay.
So what we have here is that Section 744.3 I'm sorry, 744.344 does not apply to the stipulated limited guardianship. Whether or not Ms. Barton did or didn't want to participate as the guardian at that point is of no moment, because the point of the stipulated limited guardianship was not to hire Ms. Barton, it was to try to protect Ms. Whiting. And case law, the Webster case indicates that as soon as the court enters the order of guardianship, the limitations apply whether or not there is or is not a guardian appointed, whether or not there are letters of guardianship appointed. The next issue is the issue of Mr. Whelan's affidavit. That affidavit is barred by not only parole evidence rule, but Section 90.408 concerning all discussions concerning resolution of claims. We haven't even gotten to the point of whether or not Mr. Whelan had anyone's authority to waive the attorney-client privilege for Ms. Whiting by discussing those matters, but we didn't need to reach that point. Under 90.408, the court could not consider that, and quite frankly, there is nothing that is ambiguous about the stipulation nor about the order that would require Mr. Whelan's affidavit to be considered. Mr. Bark's affidavit doesn't say anything about what occurred at the time, and really let's pull back to collateral attack on this order. There was no claim during the guardianship proceeding, up through and including the time of Ms. Whiting's passing, that this order was invalid for any reason whatsoever. So, I'm sorry.
When did your client find out about the change to the trust?
After Ms. Whiting's death.
And the appellant has suggested that they are seeking two remedies. One is for us to rule as a matter of law that under the guardianship statute, Ms. Whiting was not barred from making any changes to her trust and estate plan, or alternatively to remand for a new trial. Do you agree that if we were to find for the appellant that as a matter of law we could rule that she was not barred from making any changes to her trust?
No, I don't think that that was the subject matter of the motion for summary judgment.
Are there competing motions for summary judgment?
There were. My recollection is that the court didn't rule on the...
There was that order denying it.
Correct. So the issue then would be, still though, I guess the question would be whether or not the court could first entertain a collateral attack on an order that was never appealed during its exigency. It was never challenged by Ms. Whiting. was never challenged by Jeff Whiting, whose lawyer was a signatory on the stipulation, never challenged by my client during the guardianship proceeding. Can there, as a matter of law, be a collateral attack on that order? So, bless you, Your Honor. Then the issue becomes on the question in count 1 of the complaint to set aside the trust, did Ms. Whiting have the power to change her trust through the Second Amendment? Now, could be some changes. Take, for example, the choice of her guardian. She retained the ability to choose her guardian. But could she give a gift? Could she transfer an interest in real estate? We don't believe that there is any genuine issue of material fact, nor do we believe there's a question of law that this court could send back to the trial court, because when you look at both a stipulation for the limited guardianship as well as the order of limited guardianship in paragraph 5, it says all gifts in any form are limited. And I think it would be almost impossible to put together a stipulation in an order to try to consider the myriad of different methodologies for transferring interests, whether it be by commercial paper, whether it be by will, by trust, by gift, by straw man. And so when you look at the term in any form, that puts everyone on notice, including Ms. Whiting, whose lawyer participated in this, signed the stipulation on her behalf, that any gift, whether it be cash, whether it be debt forgiveness, is limited, and she just simply can't do it.
You had started out by saying that the purpose behind this guardianship was to prevent the dissipation of her assets.
Correct.
Presumably during her lifetime. And I think one could certainly understand that we wouldn't want, a lawn service coming up saying, I've just mowed your lawn, please pay me $5,000 for mowing your lawn. And certainly I think that's fair, and that the children would have obviously a concern if those types of checks were being written. But what does that have to do with her decision as to who gets her property after she dies, or the property in the trust? How does, I'm struggling to see how those two things are consistent with one another. If the true concern was she's writing checks to other people that she shouldn't be writing, how does that then remove from her the power to say, this is what's going to happen to my property after I pass?
When gifts are made, gifts can be requested, gifts can be given without request. When we look at the totality of the circumstances, the original temporary emergency guardianship was filed by her longtime attorney, Terrence Dittmer, because there was a concern that Jeffrey Whiting had taken advantage of his mother to enter into a deed and mortgage for the house that Jeffrey Whiting was living in for a price and a term that was not reasonable, and that Ms. Whiting didn't want to go through. And so that's the background that we start with in terms of what was going on in Mrs. Whiting's life and what was going on with her assets. And so then to get to where the court's concern is, the gifts can be given with a inter vivos moment that has a testamentary impact. And what we're trying to do in all of this is, in essence, draw a line around Mrs. Whiting that says, this is where it stops, this is status quo in terms of gifts, and this is the best methodology to do that. Equitable title to real estate is transferred in a trust. The legal title may not transfer until after the trust is completed, whether it's by a testamentary document or otherwise. Same thing can occur with a gift. You can deliver a note but say, don't do anything on the note until my passing. There are a myriad of ways that gifts can be generated that transfers of interest in real property can be generated. And so when we lay down the Second Amendment, the plaintiff has admitted in his answer to his complaint that the Second Amendment eliminated the obligation of the trustee to make equalizing payments of $153,000 to Anthony Whiting and to Nicholas Whiting. He admits that the Second Amendment eliminated the equalization of the gifts. He admits that the Second Amendment changed the beneficial interest in all trust real estate, and admits that his interest in the real estate increased by 66%, so that you can't do by one method what you borrowed from doing by the other. And we believe that there is no genuine issue of material fact, that Mr. Whelan's affidavit was not to be construed by the court. Mr. Barks' affidavit didn't bring anything to the table. In essence, what Mr. Barks did was simply give his own opinion that doesn't bind the court whatsoever, and quite frankly, doesn't come into account when the trial court is trying to construe the effect of this order. We believe that Mr. Whiting, Jeff Whiting, has admitted in his answer that he is barred by res judicata from attacking this order. He admits that in his answer. There is no reason to have any construction, and we don't believe that any of the facts that the appellant outlines has anything to do with the court's construction of these documents. Thank you very much for your time.
Thank you.
May it please the court, Clayton Simmons, co-counsel for Mr. Jeffrey Whiting, the appellant. I'll just take a moment of your time. Judge O'Kane, you put your finger on the exact issue here. This order that is on appeal was construing a limited guardianship that did not anywhere limit Ms. Whiting's ability to change her trust estate. Had the appellee wanted that limitation among all the limitations that are set out in the limited guardianship, they could have simply put that in there. It could have said, including among the other things, it could have said she can't change her trust estate or her estate. It doesn't say that. We're not here about Ms. Whiting's competency. We're not here about whether the amendment to the trust was fair and equitable. We know that there's been conflict in the Whiting family for many, many years, and what Ms. Whiting chose to do or not do was up to her. As long as she had the capacity to do it, there's no question she had never been declared incompetent, and there's no question that the limited guardianship took away from her that sacred right of controlling her estate. So we believe that this court should reverse the summary judgment and find that Ms. Whiting had the ability to change her trust. I might answer any questions. I'd be happy to. Otherwise, thank you for your time.
Thank you. Okay, thank you very much. Well argued on both sides.